Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 29-year personal injury lawyer, and this is the podcast where we talk about all things personal injury law related. Now, having said that, today we've got a little twist. We've got a Taylor Swift twist, if you will. You may have seen the news this week that somebody was arrested for trespassing on Travis Kelce's house or property. And I don't know if you've seen the full story, but it's interesting. And we are going to talk about potential causes of action that Travis Kelce would have for this trespass situation. But we're also going to talk a little bit more about legal process because the story behind this is an interesting one. But basically, around 2 a.m., a man jumps a fence on a private estate in Leawood, Kansas, trying to deliver papers, legal papers, to someone inside. And again, that someone was Taylor Swift, and the property owner was Travis Kelce. So, what is this all about? The papers that were attempting to be served were for a deposition. And it's a deposition that's tied to an ongoing dispute between actor director Justin Baldoni and actress Blake Lively. And so here we go. This case that originates out of another state far away from us here in the Midwest finds its way this direction. And it's pretty crazy here in Kansas City how now we have celebrities and things happening that we just wouldn't have thought was possible a few years ago. But Baldoni's team wants to depose Swift. And a deposition is where the lawyers sit down with a witness. There's a court reporter. Everything is taken down in writing that is said in that deposition. And that deposition testimony can be used in court. So if a trial ends up happening because of this case that's going on, they could use Taylor Swift's deposition testimony in that trial. And more than likely, they would have it videotaped so they could actually play the videotaped deposition testimony of Taylor Swift in court, just as if she was in the courtroom whenever this trial takes place. The reason you do this, obviously, they believe Taylor Swift has information that is helpful to them in their case. And they're trying to do a deposition because whenever this case goes to trial, Taylor Swift may not be available. She could be obviously anywhere in the world. So they want to get her in a room, get this testimony secured so that whenever the trial occurs, they can play it and they don't have to worry about where she is and what her availability is. But what's interesting is, again, Baldoni's team, they want to sit her down. They want to ask her questions. Again, they're claiming that she may have relevant information concerning communications, pressure, influence in this dispute between Baldoni and Lively. Swift's legal representatives, so of course, Taylor Swift has lawyers, and they're not happy about this. They've countered that she had not agreed to be deposed, that she has no material or direct role in the matter beyond licensing a song, and that she learned of the subpoena efforts just very recently. In filings with the court, Baldoni's counsel asserted that Swift had accepted a date in October 20th, to be exact, to sit for her deposition, but the court denied their motion for an extension for that purpose, in part due to lack of diligence in scheduling. So again, Baldoni's lawyers, they're trying to get this deposition scheduled. They made a motion with the court to extend the time that depositions could be taken. They're trying to nail down Swift for a deposition. And the court said, no, I'm not going to give you any more time. It either needs to happen within the time previously allotted or it's not going to happen. So, what it appears is literally, I think the day before this happened at Kelce's property, the court made that ruling. So, I'm assuming the lawyers started scrambling and they said, we have got to get Taylor Swift served with a subpoena, which a subpoena is the legal document that has to be physically served on a person. It has to be handed to them, or it has to be handed to somebody at the residence that's over the age of 18 that could accept for them. But in any event, you got to get this in her hands. And if it makes that connection, then she's legally required to show up for the deposition. So obviously, these lawyers started scrambling. They got this process server. That's a person you hire that will go out and try to physically make contact with the person you're trying to get those papers to. And they obviously said, you got to get her served. Again, these are some of my assumptions, but based on my many years of experience, I feel pretty confident that's what was going on. And so this legal process server decided, I'm going to roll in the middle of the night and make something happen. So this trial is actually scheduled for March of next year. And so the time is running out for Baldoni's lawyers to get Taylor Swift sat down for a deposition. And again, there's been a lot of back and forth. When the judge denied the extension, the judge wrote the Baldoni's team had offered no evidence that they had served a renewed subpoena on Swift and that their justification for getting extended was inadequate. They also noted that at one point, the Baldoni lawyers had withdrawn their prior attempt to subpoena Swift. So I'm not going to comment on exactly what's going on with the legal team for Baldoni, but there's been a lot of back and forth as to whether or not they were going to take Taylor Swift's deposition. But for whatever reason, they are now wanting to get her in a deposition. And so they're making this last ditch effort to get it done. But here's what's interesting about all this. And why do I include the backstory? Because it's not a random intruder showing up at Travis Kelce's house. Obviously, the initial thoughts were this is somebody that had either ill intent for whatever reason, was trying to break into Travis Kelce's house, or maybe trying to, well, we'll leave it there, right? That's what it looked like. But then we find out exactly what's going on. And this legal process server was a former police officer turned legal process server. He's probably a private investigator as well, if I were guessing. Usually those two go hand in hand. And again, this attempt in the middle of the night to serve Swift is tied to this high stakes litigation that has a lot of media exposure. Let's look at legal process tools, right? That's one thing I wanted to cover today is what does it look like when you are in a lawsuit, you're trying to put your case together, what does it take? Because you got to have evidence. You file a petition or maybe it's called a complaint. It depends on the state, depends on whether you're in state court or federal court, but whatever that looks like, you file paperwork making allegations. But then you got to prove those allegations, and you do that with evidence. And one of those tools for gathering evidence is subpoenas and depositions. And so, again, you can have a subpoena where you're trying to get a person, or you're trying to get documents, or you're trying to get a person with documents. But again, all of this is in the effort to gather testimony, preserve testimony, use it for cross examination or possibly impeachment, which just means you're trying to show that somebody's not telling the truth. So, as a general rule, subpoenas, again, must be served basically in person, certainly in Missouri. And again, different states may have different rules and ways of going about that. And federal court may be different than state court. But as a general rule, you just have to assume you need to get a person personally served with that legal document. But what's important to keep in mind is that generally process servers cannot violate property rights, i.e., trespass, to get that service accomplished. If access is blocked, if it's a gated property, a fenced property, servers must attempt methods consistent with law, or they must obtain court permission to do something different. And the risk of abuse of process, I use air quotes there, if service is carried out improperly, is there. If you're doing something that you shouldn't be doing, there's a good chance a court is going to strike the subpoena and not allow it to go. Now, when you're served with a subpoena, you can file to quash the subpoena, which makes basically you're saying the subpoena isn't valid, or you may have other reasons. You may say that it was improperly served, that there's undue burden for having to appear. They may be claiming privilege that, for example, the information they have is protected by attorney client privilege, or you might even be claiming that whatever the party that has subpoenaed the person is claiming is relevant isn't relevant. So just because you get served with a subpoena doesn't automatically mean you're going to go and comply with the subpoena. You can certainly file in court reasons why it should not be held valid and you do not have to appear. The court has power to sanction and suppress evidence if the service is invalid. And again, there are ethical limits on attorneys and the people that are working for them, legal process servers, and they cannot resort to force or illegal acts to get someone served with legal papers. So again, in this situation, the process server apparently climbed over Travis Kelce's fence. His house, it sounds like, is completely surrounded by a fence and it's gated. And this man climbed over the fence to reach inside, which raises the question, was the server overstepping property boundaries just to deliver papers? And what we do know is he was arrested, most likely for trespass. And so it certainly looks that way from all of the initial appearances. So, again, looking at the news stories, the man jumped the property's fence, and this was in Leawood, Kansas, to serve these deposition papers. He was arrested for criminal trespass under Kansas law. And again, Swift's team denies that she had agreed to any deposition, and they argue that she was not properly served. And the court denied Baldoni's requested extension to depose her, partly citing the absence of proof of renewed service. Again, Baldoni's lawyers were arguing that they had gotten her served, but apparently the court was not buying that had ever happened. So, was service likely valid or invalid? These would be the questions that would arise here. And the server apparently entered this private property without consent, and this likely violates property rights and would most likely make the service invalid, even if he had made the connection, which it doesn't sound like he did. The other analysis will be, was there a lack of less intrusive alternatives? Was delivery to Swift's attorney, for example, or by mail, if that was authorized, attempted first? Did the party seek court approval for an alternative to physical service? The court criticized Baldoni's team for filing the extension request late and failing to show they had reissued a subpoena. Again, this was like the day before this occurred in Kansas. Even if the court thinks the deposition is important, that does not excuse improper service. The process must still respect legal boundaries. And that's something to keep in mind. Whether or not this witness has key information in the case, that's a separate issue as to, have you gotten this person served appropriately? And this is just one example of the difficulties of a lawsuit. Lawsuits are hard. There's a lot that goes into them. There's a lot of rules that surround them. And it just highlights why you need skilled lawyers involved to make sure things are being done appropriately. Now, the other part of this is, you can only imagine how hard it is to get someone like Taylor Swift served with a subpoena. This isn't Joe Blow off the street. Taylor Swift is constantly surrounded by security. She is, every place she lives is probably secured. Example, Kelce's house, surrounded by fence and gates. And it presents a real struggle for the lawyers trying to make service. And I've been here personally in my legal world, when people are trying to dodge getting served, to do a lawsuit and file that initial paperwork. You file that with the court, you get a summons back from the court. The summons says, once the person is served with these papers, they have to respond. And a lot of times people know that a lawsuit is coming and they don't want to get served. And they do everything they can to hide. And it takes a lot of effort sometimes to get people served with legal papers. I can appreciate what the Baldoni lawyers are going through, especially with somebody like Taylor Swift, who doesn't want to be served and has a lot of ability to avoid that service. But again, the law requires that you do things appropriately. Without that, without doing things the right way, they're going to have a very hard time getting Taylor Swift sat down for her deposition. Even say they do get her in some form or fashion, all the arguments are there for her lawyers to try and prove that it was not good service, that an invalid method was used. They can work to suppress any deposition result or testimony that was gained by that service. So even after the fact, let's say they go ahead, they have her deposition, the lawyers for Taylor Swift or for Blake Lively, whoever doesn't like the testimony can still argue somewhere down the road that the service was no good. And so the testimony should not be used at trial. Again, there's the argument that the service was an abusive process, which is basically just saying that you're using the legal system in a harassing way, essentially. And again, that could definitely go against the person that is attempting to secure that deposition testimony. And finally, like I say, this legal process server, he's obviously facing criminal trespass charges, and that could undermine the legitimacy of the attempt at service. Again, if the court finds the service invalid, they may decline to compel Swift's testimony. If Swift's deposition is suppressed or excluded, again, Baldoni may lose access to what he asserts is relevant evidence. The client side, Swift Lively, may move for sanctions or cost shifting for improper service, if they have to go through and they have to fight this out in court, they very well may ask the court for their attorney's fees and any other extra costs that are incurred because of invalid service. And again, none of this ever looks great, right? If you are the lawyers for Baldoni and you've got a guy out there trying to serve papers in the middle of the night and trespassing at somebody's home, that doesn't look good. That can create obviously a public relations backlash, things like that. And again, this is one of these high profile cases. So everything is under a microscope. So now let's just turn a little bit. What about Travis Kelce? This guy who obviously has no part in any of this, but because of his relationship with Taylor Swift, he's in the middle of it. And obviously, Baldoni's lawyers figured out that Taylor Swift was staying at Travis Kelce's home in Kansas. So they obviously had this guy go to try to make this service, but Travis Kelce is the owner of the home. He's the one that has any potential civil cause of action against this person for his actions. And I always talk about the difference between criminal and civil. Criminal, again, that's the state bringing criminal charges against somebody. But then the civil side is where you're seeking damages. A person is seeking damages for whatever the alleged tort is. And tort, again, is not a breakfast food. That is the term that we use in the legal world to describe things like trespass. Again, we describe things like negligence. Everything falls under that. Car accidents, falls, trespass. There's intentional torts, trespass. There's unintentional torts, negligence, car accidents, things like that. So again, Travis Kelce in this situation very likely could make a claim against this process server and potentially even against Baldoni's lawyers because they're the ones that hired this guy, and he could make a claim based on the entering of private property and attempting to serve these papers. Again, it could constitute an intrusion even without physical damage. There's an intentional intrusion. It's a privacy tort. So he does have claims potentially against this guy. There's even a chance, because of the intentional nature of this, there's a chance that he could claim intentional infliction of emotional distress. And why is that important? Especially given the timing, middle of the night, you've got somebody rolling in to your property. Obviously, Kelce Swift, we assume, or awakened, something alerted them that a guy was on their property that clearly they didn't invite, they weren't expecting. And there's a lot of stress that goes with that. Travis Kelce, Taylor Swift, they're in a whole nother world now. Or I should say, Taylor Swift's been in a whole nother world for a long time. Travis Kelce has found himself in a whole nother world now because at this point, there's a lot going on. There's a lot of people that would like to try to get access to both of them. But when you're in the middle of the night, you're asleep, somebody rolls up on your home, you're alerted, you don't know what's going on. Again, intentional infliction of emotional distress is a real claim that actually both of them, Kelce and Taylor Swift, would have against this guy. There's the invasion of privacy, intrusion into solitude. If the event involved entering near parts of the home or private areas, again, we're not real clear on how close to the house this guy made it, but that's another potential. And again, if for any reason the guy damaged anything in his attempt, then there would obviously be a claim for damage to property. If a fence or gate was damaged, that type of thing, they would have a claim for that. And potentially even a nuisance claim or a continuing interference claim if attempts are repeated or ongoing. Again, we don't know Is this the first time this has happened or not? Certainly, it's the first time we're hearing about it in the public realm. You could also, in a civil claim, you could put in any civil remedies for violation of Kansas criminal trespass or harassment statutes. There could be claims under Kansas privacy statutes or anti-stalking laws. And there could be, again, this is an intentional tort situation. So punitive damages are always possible, which remember, punitive damages are there to punish and deter. And so at that point, you could not only claim for punitive damages, but possibly also getting attorney's fees awarded for having to go through this process of attempting to get compensated for this violation. Now, this guy, Baldoni's lawyers, whoever might get sued out of this, they would defend themselves, arguing justification that this was for a legal purpose. And again, unfortunately for them, that usually doesn't override property rights. You can't violate the law to get somebody served. They might argue consent if somehow the homeowner had granted implied permission for them to come in. Again, pretty far-fetched, right? Because I don't think they were expecting this guy at 2 a.m. Mitigation obligations, they might argue that the homeowner should secure their property, install deterrence. Again, all of this is really weak. If you're defending a lawsuit, you probably are going to throw that out there. And finally, Kelce, Swift, they're going to have to prove actual harm. They're going to have to prove emotional distress, fear, potentially cost of security upgrades. There's a chance, we have no idea what Travis Kelce's security situation looks like at his home. But if he goes out and spends a bunch of more money to further enhance security, he could claim that as damages. But as far as compensatory versus punitive damages go, as on the compensatory side, they're going to claim any repair cost, any security upgrades, any diminution in value of the property because of this. Very difficult to do. If your property becomes a place that is regularly getting trespassed on, invaded, however you want to look at it, when you go to sell that down the road, now again, most people are going to realize this is when Travis Kelce lived here, and Joe Blow probably isn't going to have the same problems. He sells it. Not necessarily everybody knows that. Are people going to continue to try to get in there? So anyway, if he could prove that somehow all of this is affecting the value of his property, it's a claim he could make. And again, non-economic damages, the emotional distress, the anxiety that went with this event, punitive damages, again, if conduct is especially egregious. And again, from what we know, it's not cool jumping fences at 2 a.m. That's going to freak anybody out. So finally, they could also ask for what's called injunctive relief, which is basically you're asking the court to enter an order to prevent future intrusions, requiring better barriers, things of that nature. And again, there's a good chance because of the intentional nature of all this, they're going to ask for all attorney's fees and costs that are associated with any claims they're making against the process server and Baldoni's lawyers. Now, because these are celebrities and high profile settings, something that very well might get weighed in all of this is the privacy expectations of Kelce and Swift. And again, the privacy expectations may be higher just because they're celebrities. You don't think they just assume the risk that people are going to be doing things like this. At the end of the day, their privacy expectations are probably higher. There's a reason that Kelce bought a house, moved from his house that's not far from my office, actually, over to this house that's fully gated, fenced, all the things. And that just may be some analysis that plays into it. Again, public relations, reputation risk, all those things weigh into it. And I have a feeling if Kelce and Swift are going to do something arising from this, they very well may have already done it. They probably have lawyers taking action because they want to prevent this from happening again. So, what are the key takeaways from this incident that happened at Travis Kelce's home in Kansas this week? His legal strategy trying to involve Swift, the service tempt, and the homeowner intrusion just highlights the situation that goes into a lawsuit where there's this legal process, there's ways of getting people involved in lawsuits, subpoenas, depositions, but they have boundaries, and you have to respect property rights. You have to respect people's right to privacy. High profile parties often tempt extreme service attempts, but the law pushes back on them. I get it. They're running out of time. These are obviously high paid lawyers and they're trying to get something done. And I have no idea if they told this guy, just get it done. We've got to get her in for a deposition. And he took that as the green light to go out in the middle of the night, attempting to make this happen. I've had it in my head. I'm trying to figure out what his plan of action was. Was he going to knock on the door at 2 a.m? Whoever answered, he was going to hand the papers to. I don't really know what the full plan was, but it makes you wonder. And homeowners, what we also need to take away from this, homeowners have meaningful civil recourse when process service goes too far. There's legal ways to do it, and then there's the outside the bounds way to do it. And if it's something that goes beyond the bounds of what's allowed, there's potential causes of action that the person who's being sought after has against those that are seeking them. If you're served with some kind of a legal paper, you think that it went beyond the bounds, you don't have to just ignore it. You can always reach out to a lawyer, find out what the story is. Was this appropriate? All those kinds of things. Again, most of the time, everything is on the up and up, but sometimes people get desperate and start doing things that just are not justified. And courts are going to look at that very carefully. And then on the other side, there are legal remedies available. So, as always, I hope you found this useful, insightful. Again, here in Kansas City, we find ourselves in the middle of celebrity interest, which we're just not used to, but here it is. And so until the next episode, I hope you stay safe, stay well.